Your doctor refuses to release your medical records. You think you may have a valid basis for a case. What do? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. You have an absolute right to obtain copies of your medical records from any doctor you see here in the state of New York. In order to do that, all you have to do is write the doctor a permission slip that says, "Dear doctor, I want you to give me a copy of my records." In all likelihood, the doctor will say, "Fine, no problem, just pay us for our copying expenses, and here's a copy of your records." And that's the end of it. However, there are some doctors, for whatever reason and various reasons, who choose not to turn over the records or not to do it in a timely fashion. So what can you do, and what do we do as attorneys when we make the request on your behalf, when we're investigating a possible medical malpractice case? Well, we encounter this situation quite often, actually more often than I'd like to. The problem is that some of the doctors who are getting these requests for records think automatically that they are being sued. The reality is that we are likely in the investigation phase. We're trying to determine who did what and why. And we, on behalf of the injured victim, are entitled to get copies of the patient's records. The patient will give us a permission slip that says, "I hereby authorize Mr. Oginski as my attorney to get copies of my records." And now we, on behalf of the patient, send that request to the doctor's office. And despite calling and sending additional letters, we get nowhere. We get no response. The doctor refuses to turn over the records. We get excuses. The doctor's reviewing the records. The doctor will get to it. It's sitting on the doctor's desk. And this can go on for weeks and weeks and sometimes even months. So here's what we can do. We can send a letter to the New York State Department of Health and copy the doctor on it and say, "Listen, Department of Health, this patient has an absolute right to get copies of her records. We have done everything we are required to do, including sending a permission slip, include sending a power of attorney from the patient that says, please give us copies of the records. And yet the doctor still has refused to do so. We need your help." At that point, the New York State Department of Health will jump in and usually intervene. But before they do that, they want to make sure, number one, that you have sent in a proper written permission slip, that you have sent in a proper written, it's called a power of attorney, that allows the attorney to go ahead and get the records, as well as the cover letter saying that you'll agree to pay for the copies. And once they've seen that, then they'll go ahead and intervene and ask the doctor why they have not turned over the records that they're supposed to do. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on into the evaluation process of a medical malpractice case here in the state of New York. You know, I recognize that you probably have questions or concerns about your own matter, and if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I do this every single day and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Have a great day.